Members, we have a quorum. I call the meeting to order. Since the last meeting, we have not issued any information paper. May I remind you that under Rule 83A of the Rules of Procedures, if members would like to speak on any discussion matters that they have direct or indirect pecuniary interest, please disclose the nature of the interest before you speak. The first item is in relation to the administration of the estate of the late Mrs Nina Wang. Paper number CB bracket 41313/14-15 Please ask Mr. Rinsky, Union Secretary for Justice, to present the paper to us. Then I will invite members to ask questions. Mr. Yun, please. Thank you, Chairman and members. Thank you for expressing concern on the administration of the estate of the late Mrs. Nina Wang, and I would like to give you some information. As protector of charities, I myself and the DOJ has been keeping close monitor on the administration of the estate of the late Mrs. Nina Wang, and also the management of the estate. We are in close cooperation with the administrator of the estate, and if needed, we will seek directions from the court on the management of the estate. We will cooperate with the interim administrator of the estate for now. In relation to the interpretation of the will, the Court of First Instance has made a ruling. Well, the CFA has made a ruling that the China Camp Charitable Foundation will be the interim administrator of the estate, and they will prepare a scheme for the implementation of the will, and that should be a supervisory managing organization, and there should be some arrangements made for the Chinese prize mentioned in the will. The DOJ is now discussing with the interim administrator in the follow-up actions. We'll continue to talk to China Camp Charitable Foundation Limited and the interim administrator. For the time being, the estate is still managed by the managing organization appointed by the court. That is the independent administrators, and if necessary, I will follow up to ensure the interests of the estate is being protected. Thank you. Now I open the floor for members to ask questions. So far, there is only Mr. Stephen and Mr. Albert Ho. Anyone else who would like to speak? There are two members who would like to speak. I will give them each 5 minutes. Mr. Albert Ho. The estate of Mrs. Wang is very complicated because we're talking about close to $80 billion. The asset is mainly held by the parent company, China Camp. The estate is now being administered by the charitable foundation. The court said that is for charity. So the court has the duty to protect the interest of the public. And the secretaries made it very clear that the court has appointed an administrator. So between the administrator, the charitable foundation, and the parent company, so when it comes to the actual control, will it be in the hands of Chinacam? And what is being done by the administrators? So what is the daily operation of the company? Because they have in their hands the estate, which is close to $80 billion, Secretary. The court has appointed an interim administrator. They have which has the duty to locate the asset of the group and preserve it. We have an interim administrator who is now doing the work. If I understand Mr. Ho's question correctly, at this stage, major operational decisions have to be made after discussion with the interim administrator, and if necessary, directions have to be sought from the court. Of course, we are concerned if there is any unusual dissipation of asset by the company. That's why the interim administrator will have to closely monitor to preserve the estate. Well, the interim administrator was appointed in 2007. It's been 8 years, and they're still trying to locate the estate. I don't think that is the case. Well, there is a parent company controlling the operation of subsidiaries. Each subsidiary may oversee, say, some properties or some construction sites. Is it the case that the administrators just sit outside to make sure that there is nothing sold and nothing apportioned? We raised this issue because a lot of members, I believe, have received information from complainants saying that in a daily operation of the company, there is littered with fraud. Is it the case that the members of the board controls the operation of the company, which holds the $80 billion? So any administrators sitting in the board? And sometimes it's not just about dissipation or transfer or apportionment. The operation over the year may be about hundreds of millions of dollars.
I've got a message saying that one of the relatives sits on the board of directors. Actually, her younger brother, Dr. Kong, is experiencing a few court cases with regard to this estate. I'd like to know whether the DOJ should be watching over this. And it is said that a lot of family members are in the company and they are receiving very high salaries. I don't know whether these complaints are substantiated, but you have to respond, because maybe tens of millions of dollars or even billions of dollars have disappeared over the years. This is about public money. Mr. Ho, please allow another member to ask a question, and then SJ, later on you can give a consolidated reply, and Mr. Ho, you can have a second round. Mr. Paul Chair. Thank you, Chairman. Like Mr. Ho, I have received complaints or comments, and also from the media we have seen some accusations about management within the Chinachem group, I have to declare that some beneficiaries have consulted me for my opinion. Right now, the DOJ is a protector of charities under common law, but day in, day out, it seems there are problems. I'd like to know whether the DOJ can rest assured that we can allow the original managers to manage the estate. There is a tripartite relationship. We have the DOJ and there are 2 interim administrators. Just like Mr. Ho said, what about the roles of these 2 administrators? From media reports, we understand they charge exorbitant fees. And will there be also this problem? And that is that these directors and interim administrators are doing something by way of operation and management which warrant the attention of the DOJ and the public. Or do we just allow them to work behind closed doors under the shadow of complaints and litigation cases? Why are the fees so high? Would there be any passing of benefits? Would some people not be doing an exact job of management because there will be beneficiaries later on under the Chinese price and the public because there are charitable elements. So I'd like to know whether the DOJ would be involved in the formulation of the final supervisory managing organization. Are you doing anything, or are you just waiting for the foundation to move at a snail's pace to come up with an option? Or is it that you just allow the interim administrators to drag their feet and then propose to the court with tardiness, and so that in the end there will be a Chinese price? I think as the days pass, money is being lost. I'd like to know what you are doing and what is the timeline. Thank you, Chairman, and thank you, Mr. Chair, for the question. With regard to complaints, we are aware of them. We have received complaints from individuals as well. On this occasion, I don't think it's appropriate for me to comment on the complaints. As you will understand, people with different background may have their own stories to tell, and their complaints may actually contradict one another. But first of all, I'd like to tell you that we are keeping a close watch, and secondly, we are holding discussions with interim administrators. As you know, in the court, there are now cases because the interim administrator is of the view that there are matters that have to be handled by the court, and these would involve some complaints being lodged. In simple terms, I'd like to say that we are monitoring the work of the interim administrator vis-a-vis complaints and the management of the estate. If legal action has to be taken, we can see that it is being taken. And also to respond to the second part of Mr. Chair's remarks, and that is what are we doing? In May this year, the CFA issued its judgment, and we did 2 things after that. One, in view of the judgment of the CFA, which states that we should draw up a scheme for administration in the future, we have already liaised with local and UK independent SC and QC respectively to seek their legal advice. And secondly, with regard to a draft scheme, we have given our views. Because legally speaking and technically speaking, the scheme is going to be complicated, and I can let you know the latest development. Last Friday, we received the first draft. We need 1 week to study the local SC and UK QC advice, and then we will write to the foundation to discuss with them. Hopefully, we can arrive at a consensus so as to save time. Our work target is, if in case there is no consensus, then hopefully within 6 months, we can try to forge a consensus. That will be our work target. If we fail to do that, we will take further action, including applying to the court for directions. We don't want the discussions to drag on end. If they do not disagree, well, we will have to do something. We cannot just allow the disagreement to be stuck there. Since we have received this draft scheme, we hope to work by a timeline of 6 months to deal with ensuing work about drafting the scheme. Can I take 10 more seconds? Will you appoint any SJ representatives or DOJ representatives onto the board of the foundation? We have discussed with our counsel. We think it is not appropriate to do so at this stage. But as we draft the scheme, there may be new developments, but I should not say more at this stage. Mr. Ma Fong Kwok. Thank you, Chairman. This is a very huge estate, and the CFA has already passed judgment. I'd like to know, as of today, through the trustee or the foundation, does the government know exactly the amount of included in the estate, and are you in the know vis-a-vis the income and expenditure of the estate in the past few years? And if you do, can you publicize those figures? And the public interest is involved because it is a charity. And also, SJ, do you have any power to state those figures in the public? Or so first of all, do you have the information too? Do you have power to lay it in the open? And also, do you intend to appoint anybody? The SG of the UN said it is not appropriate for it to do so, and the Chinese premier did not reply. I'd like to know whether the SARG would urge the Chinese government to respond. And when you replied to Mr. Paul Chair, you said you should not divulge more. Why not? Because this is an arrangement under which you can exercise your public power. You should explain what you intend to do. We are not talking about litigation. We are talking about the government exercising its public power to monitor something of public interest. Also, in the past period, since we know this has dragged on for very long, the accounting firm has charged an exorbitant fee. I'd like to know whether that is a reasonable level of fee charging, and whether indeed such a big sum has been needed or required. And also, have you done anything to really do financial regulation so as to make sure that the assets have not or has been properly preserved? And would anybody be able to take the place of the accounting firm? Well, I can't say this is really public money per se, but this is an asset that is related to the public interest. Thank you for the questions. First, information at hand shows that the estate is about $82 billion. And as for the estate and other details, on a regular basis, the interim administrators supply reports to the court. And the relevant parts of the report are regularly submitted to the DOJ. So the DOJ has a team to read the reports, and secondly, to respond to what Mr. Ma said with regard to the fees charged. In fact, the fees are monitored by the court and are charged according to the court orders directing the appointment of the interim administrators. In the community, some people say they are high, they are exorbitant, but that depends on individual judgment. What I can say is that interim administrators, just like the liquidators of companies, their fees are charged according to court procedures. If the DOJ or the court or anyone should think that the fees are unreasonable, there are relevant procedures to request the court to do an assessment. So it's not up to the accounting firm to charge any fee it likes. Mr. Feng, you talked about the three parts. First, the SG of the UN and the Chinese Premier and also the CE of the Hong Kong SARG should be involved. And we are actually looking into the technical side of things. For example, with regard to the UN SG, whether technically speaking, whether the SG can be one of the supervisors of the Chinese prize. There are legal issues concerned, and since the UN is an international body, there are issues of diplomacy. We are seeking legal views. Overall speaking, to answer Mr. Ma's another point, if the three all say they are unwilling or they regard themselves inappropriate, there is another possibility, and that is, with the permission of the court, we can appoint professional trustees. Or famous and independent people locally or from overseas. This is allowed under the law, and there are precedents. Especially, professional trustees in Hong Kong have been appointed in other case law. A recent case is about the Qingshan Monastery, whereby the court permitted a professional trustee to take up the job. So on the one hand, as I said, we are preparing the scheme. On the other hand, in terms of the supervisory managing organization and the three parties proposed, we are doing preparatory work, including when there is a need, we may apply to the court to have a professional trustee or some neutral, independent people from Hong Kong or the UK who are widely accepted to be appointed. So we are doing a few things at the same time. I think you have not responded to one point, and that is how many people at the DOJ are handling this matter. At the present stage, since only in May the CFA passed final judgment, and I can tell you that at this stage, since the start of the case until this stage, under the Civil Law Division, there is a team of colleagues working on this.
Depending on the scheme, we may need to increase manpower. And in relation to our work and that of the future, we think that there will be an increase in workload. In the right time, we will have an assessment to see how many more people we need to work on this. This is a sizable estate. And at this stage, it's difficult for us to give you a figure, but I think I can safely say that we will need more people in the future. You will have to wait for the second round. I still have, there is still me in the first round. There are 3 people in the second round. Let me ask questions first. Well, I know two of the sisters, but that's it. We've hosted a program together, but that's that. And I have some questions for the secretary. Some family members are involved in litigations. So is it the case that you have to wait for the litigations to complete, and that's why the professional accountants have not yet made any major decisions? I think that for the interests of the public, transparency is very important. You have to tell us why certain charitable projects are supported, and why you appoint certain people into the board. So you have to give us a timetable. And you need to inform the public as needed. Yes, there are litigations, but the object of our work, which is within 6 months, we will talk to Chinacam Charitable Foundation about the future scheme, which we will try to reach a consensus. Otherwise, we will seek directions from the court. This is not related to the proceedings initiated by the interim administrators. Those proceedings are related to individual issues. It's not related to the estate as a whole. My view is that we shouldn't be led by the nose by these proceedings or litigations. Otherwise, it will have a huge impact on the management of the estate. Because as you all know, no one knows how long it will take for the proceedings to complete. There may be some interim hearings, and there may be appeals. It's not easy to make an estimate, and it's beyond our control, because these proceedings are not initiated by the DOJ, but by the interim administrators. So taking everything into account, we will not be dictated by proceedings that have already been initiated. You use 6 months. So is it the case that you already embarked on discussions about operation, about appointment of board members? So if the negotiations are successful, then you will have a scheme, without failing that, you will be able to seek directions from the court and have everything in place in 6 months' time, right? Yes. In May, the CFA delivered a judgment. So major directions have been covered in the court's directions. And in accordance with the directions of the CFA, we have sought advice from local and overseas SCs and QCs. We've asked them to give us a draft of the scheme. At the end of last week, we've just received the first draft. What we aim at doing is to use this week's time to go over the first draft to see if there are any matters that need further clarification or refinement. The next stage is to meet with the representative of the charitable foundation. So when I said 6 months, if at the expiry of 6 months, if we cannot reach a consensus on the scheme, we will still have a framework of supervision to submit to the court Of course, the charitable foundation has rights to raise any issues and for the court to consider. The court will consider representation from both sides before deciding on the scheme or giving directions, and that will be related not to principle. Second round, we'll start with Mr. Alberto, 3 minutes. The crux of the problem, as the Secretary said, is to reach consensus with the other party. The other party meaning what? The charitable foundation. You shake your head. Then who? I thank Mr. Ho for his question. The main point is not to reach a consensus with the other party. I've made it very clear that the first step is to sit down and discuss with a representative of the charitable foundation, because that is also one of the suggestions of the CFA. We shouldn't just go to court without first going through a discussion. So let me say that we don't have to do that after they have given us the consent. We've set down the work objective of 6 months because we need to have some discussions, and if after 6 months and we cannot have a fruitful discussion, then we will make applications to the court for directions on the framework of the scheme. In principle, the administrator will have the most power. It is just that the charitable foundation is a trustee. I don't want to get bogged down on the technicalities. So when it comes to the actual operation, the one that is managing the $80 billion is the charitable foundation, which is done through the board by the Kongs. What we are concerned with is dissipation of the estate. The administrator received a huge sum to manage the estate, but what are they doing? They are not involved in the daily operation. They're only there to make sure that there is no distribution of the estate, no dissipation. SJ. I understand what Mr. Ho said, and I fully understand the concern of the public. In short, it boils down to 2 issues. First, the interim administrator has the duty to make sure that there is no dissipation of the estate, or no unreasonable or inappropriate dissipation of the estate. We can make applications for relief from the court if there is any mistake on their part. When it comes to supervision, apart from the interim administrators, there are also outside parties. As members mentioned, someone outside the Kong family are appointed to overlook the operation. Of course, it won't be down to minute details like the individual staff members. But apart from the interim administrator, then there are outside managers participating in the operation, being involved in major decisions. So on 2 levels, there is supervision. I understand public concern, but there is a mechanism in place dealing with that. And this approach is agreed by the court. Mr. James Toh will be speaking for the first time, so let's let Mr. Toh speak first. I'm not going to repeat public concern because Mr. Ho and other members have already covered that. For example, with the consent of China Camp Charitable Foundation appoint a number of people nominated by the government to participate in the foundation. May I clarify from Mr. To? You're talking about the current operation or when there is a scheme in place? Now, I mean. Save and except their exceptional circumstances, I don't see any reason why we need to appoint anyone to be involved in the foundation. Please let him finish. The current managing organization is something that has been submitted to the court, and the court agree that this is the right approach. Well, it's my request that the S4J to monitor the operation of the charitable fund. I am a legislator, and I can tell you that the public do not trust the charitable foundation, and they're not happy with the current arrangement. If you can find people you trust to sit in the board, then our concerns will be dispelled, because you can minimize the chance of untoward arrangements or decisions. Well, I see that Mr. Alberto nods as well. So it's not about the future scheme, it's about now. And if the charitable foundation disagrees, what can you do? Can you go to the court to ask for an appointment or what? Of course, if you're on speaking terms and if they are agreeable to having someone appointed by the government to help, then it's good. So I ask you directly to do it, to protect the interest of the public. Anything to say in reply, Secretary? I understand Mr. To's suggestion. I'm not saying that I will refuse you outright, but if we are to go down this road, we have to first carefully consider who to appoint, and when we make an application to the court, how are we going to proceed with the discussion with China Camp? There are considerations we have to take into account. If we go down this road in a way, we are overturning the current arrangement, do we make an application to the court? How will the court react? We have to take that into consideration. I'm not saying that we won't do it, but we need to consider it further. I'm sure today is not the first time you have heard this. I ask you to actively consider it. Well, at the outset, I think you're quite reluctant. It seems like you're quite happy with the current arrangement and that the court is happy with it as well.
Yeah. But I can tell you that many people in society are murmuring every day. But it is not easy for other people to be able to do anything. I don't know whether you have got such information. From what I see, I believe some of the information should have gone to government. I hope you will think from this angle and do something immediately to protect the public interest. SJ, Chairman, please give me some time to respond. I'd like to thank Mr. To for his suggestion and his reasons for concern. You say there are people murmuring in society. Well, I have heard those, but I don't know whether the information you have got is the same as what I have got in terms of quantity. But I just like to say here that since many people's interests are at stake, because of this incident, and many people are talking about their own observations because of their positions. So is it that when somebody speaks up, he must be right? I think we need to give every comment some objective consideration. Now, we cannot rule out that these comments and concerns are well-founded and are reasoned. And we must carefully consider every complaint and every observation. But what I want to say is, it shouldn't be just because people are murmuring outside. No, when you appoint somebody, you have to get one who has high credibility. The thing is, you have not appointed anyone on the board of the foundation. Okay, I think your views are very clear, and I think the SJ has heard you. Second member in the second round, Mr. Paul Chairman, I totally support what Mr. James Toh said. As a matter of fact, the SJ has said that this is the mode directed by the court. I'd like you to give me papers to tell me whether you are just talking about the framework, or is it that the court has been informed of the actual appointment of the directors? I don't think so. I have heard accusations, and information I have got point to the fact that some relatives who actually have been operating lifts only are now appointed directors, and they are given huge remuneration. Now, I don't know what monitoring you are talking about. So what has the court approved? And two, I want to know the background, qualification, remuneration of all the directors of the board. If you don't have it here, I hope you will give me a supplementary paper so everything will be transparent, so the public will know whether the board should be trusted, or is it that they are working behind closed doors, only abusing powers because there is no monitoring or regulation. I think you have to do that. And my own worry is, SJ, please pardon me for saying this, the DOJ plays a monitoring role. In fact, you receive no professional fee, and it is a very complicated issue for you to handle. Every day, every hour, the interim administrators would be charging the fees, and they don't mind the matter dragging on. The interim administrator has been appointed in 2007, and then in 2013 there was the judgment of the CFI. Why did you not do anything, or the interim administrators not do anything? Why did you have to wait for the CFA judgment? In fact, once there was a CFI judgment, things should have moved ahead. And I don't understand why we need to have overseas QC and local SC to review the framework. You just have to look at the existing mechanism, and then you can take note of the Shaw Foundation in Hong Kong. Those basic frameworks will work very well. There are no legal disputes. Why do you have to engage UK QCs and to draft the scheme, and you say you have to take 6 months to try to forge a consensus? This is quite unimaginable. Is it because the DOJ doesn't want to do it that you don't have money to do it? If that's the case, let the foundation pay the DOJ so it is more willing. Or if you are not happy to do it, you don't have resources, you don't have time and money, let us help you create some posts. SJ, please respond. You have very little time left. Thank you, Chairman. Definitely, it is not as what Mr. Chair said, that we have no money or we are unwilling. We have been working all this time. This is very unfair to our colleagues. And Mr. Chair said, why do we want to defer to overseas QCs? We should just look at the Nobel Prize Foundation or the Shaw Foundation. I think this is quite limited in the scope of the view. The managing scheme is one thing. The Chinese prize is another. The setting up of the Chinese prize is already a subject we are researching into to see whether we can have any reference made to the Nobel Prize Foundation and the Shaw Foundation. But this is something very different from the setting up of the managing organization. And also whether it be the UK or Hong Kong, we don't have that many precedents. In the UK, there is a dedicated charitable foundation supervisory organ. And in fact, this is also an area of research for QCs. I don't understand why Mr. Paul says that this is a kind of postponement or stalling on our part. I think that is very unfair for the DOJ. I hope you don't have that view. As to whether the documents can be made public, I don't mind going back and trying to see what papers are allowed to be made public by the court. We are not hiding any papers. We have no intention to do that. Unless the court says there are some papers which must not be made open as directed before, we will be very happy to go back and take a look and supply those papers to the panel. As to whether the DOJ has no interest or no money to do this, as I said, we do have a team of colleagues working on this. Whether we need more colleagues in the team or more resources, if we do, we'll definitely come back to the panel or other relevant panels. It is not that we don't have an interest, because if indeed we had no interest, we wouldn't have taken the initiative to go to the court for starting some litigation, including how we should interpret the 2002 will. That was raised by ourselves. If we had not been interested or we had not wanted to do it, we wouldn't have started that case. Next, Mr. Ma Fong Kwok. Also, I wanted information about the members of the board. Okay, we'll deal with that later. Mr. Ma Fong Kwok. Thank you, Chairman. I'd like to express my views here. The public are very concerned and they have high expectations of this matter. Once the CFA reached a judgment, I believe the power has been handed over to the DOJ. And then with the power comes the duty. No matter how the SJ feels about this case, it is your duty now to do it. Now, how you can meet public expectation, as Mr. James Toh said, I think that is very reasonable and legitimate. It is also my own view. I think you should work fast. The case has been dragging on for a long time. The DOJ, actually including the former SJ, you should know very well that you have a role to play. And you should really think through the matter and be prepared to handle it and not allow it to drag on anymore, because it will not do any good to the public interest. Secondly, the SJ said that it is estimated that the estate is of an amount of $82 billion. But that was a very old estimate. I'd like to ask you, SJ, do you have a checklist of the assets of the estate? What are the assets that could be re-evaluated? And what will be the value if there is re-evaluation? And can that be made public? Because then the public will be able to monitor the assets. If the assets are put up for any negotiation, I believe the public will be able to help to issue warnings. I think the SJ should try to secure such information to add transparency to the estate so the public can monitor it. And then you should exercise your powers and discharge your duties. Well, I'm not saying you should intervene, but discharge your role, because you cannot evade from your role. Can you give the SJ some time to respond? SJ, thank you, Mr. Ma, for your question and your view. Mr. Ma, your view is not in contradiction to ours. We do agree that with regard to the protector of charities role, as the SJ, we know our role clearly under the common law, because we are a protector of charities. Whether it be the former SJ or myself, we do hope that within the scope allowed, we can discharge our duties. And that is why I said we initiated the interpretation of the will. And in fact, we were getting ready for other matters as well. But because we did not have the final judgment, we could not finalize a lot of things. As to Mr. Ma's second point, we can go back and consider it, and wherever possible, we will try our best to do it, because we do understand that the public have shown concern. Now, whether we can have a checklist of assets under the estate, we can go back and consider it. But at this stage, what can be made public, what cannot be made public, even if there is a checklist, it's going to be long. We will have to see what can be made public. Okay, Mr. James To, second round, and I have to draw a line there, or else it would not be fair to the second item. After Mr. James To's second round, we will wrap up the discussion of this item. Strictly 3 minutes for you, Mr. James To. Chairman, I have heard Mr. Ma Fong Kwok's view. I think he has a brilliant idea, and that is the publication of a checklist of assets. I don't think it should be difficult in any way. You would say it is such a huge amount. Maybe you would just want to publish assets valued over $10 million, or else the checklist would be extremely long. When you draw the line, then perhaps it should be a few millions or 10 millions. I think the assets are mainly buildings, shares, etc. I hope you can make it public within a week. If you say there is no checklist, or you want to make sure whether there is such a checklist, then it will be quite alarming, because we don't know what the foundation is doing. You know, people publish annual reports about public trusts. Well, let me give you 2 weeks, not 1 week. You should be able to publish that with no difficulty. I cannot think about any secrets involved. It should not be a secret for it to hold some land or some companies or a patent. Well, if the patent has to do with some military secrets, which has to do with the survival or otherwise of the entire country, well, I don't know. Maybe I'm too imaginative. Otherwise, you should be able to produce that checklist within 2 weeks, at least with regard to assets that are valued at a certain level. Then you give people the impression that you are doing something, and the entire society will be able to do the monitoring together. Okay, SJ. Another member has asked about a list of board members of the foundation. 1 minute for you. Okay, I will go back and consider all the details. As I was telling Mr. Ma Fong Kwok, if the law allows it, we have an open mind with regard to the checklist. We don't think there is anything to hide. That is not our aim at all. But we must be careful and go over court orders issued so far to see whether anything should not be made open or published. Because I do remember that in some orders issued by the court, there were such terms. I will have to go back and check it. As to whether we should appoint government officials to sit on the board of the foundation, we'll have to consider what is the best way to do it. But the major direction or the principle is, we understand your concerns, members, and we understand what you are telling me about concerns and worries of the public.
We do hope that we will be as open and transparent as possible, but still, it has to be monitored by the court. We have to strike a balance, and we have to study on whether to make further applications to the court. Let's move on to the next item. Yes. Members asked for information, and the Secretary said that they will have to look into it before deciding. Next is implementation of the recommendations made by the LRC, Law Reform Commission. Paper CB bracket 41313/14 to 15 bracket 02 and 03. One is the implementation of the recommendations made by the LRC, and the other one is an updated background brief. First of all, I ask the Secretary for Justice and the Acting Secretary of the LRC This is the third time when I make a report in accordance with the decision of the reporting mechanism introduced in 2012 about the progress of implementation of LRC's recommendations. I am the SJ. I'm also the chairman of the LRC. Of course, we have to make sure that Hong Kong's legal system keeps up with the change of the times and to make sure that they are effective. I myself, the Chief Justice and other members of the LRC attach a lot of importance on the selection of suitable topics for the consideration of the LRC. We'll continue to respond to the reports of the LRC. Members, you will have received an information paper. It's a table setting out information of every single report since they have started compiling reports in 1982. There has been altogether 64 reports on civil and criminal matters. Out of the 64 reports, there is one report that suggests no change to the existing system. For the remaining 63, they belong to 5 major groups. First, proposals implemented in full. There are 34 such reports. That is 54% of the 64 reports. The second group is proposals implemented in part. 7 reports, accounting for 11% of the 63 reports. The third category is proposals under consideration or in the process of being implemented. 17 reports, accounting for 27%. And the fourth group is proposals rejected outright by the administration. 3 reports, accounting for 4.8% of the 63 reports. Lastly, the administration has no intention to implement the proposals at this juncture. 2 reports, accounting for 3.2% of the 63 reports. So far, there are still some reports that have been implemented by legislative amendment or administrative means. Apart from the 41 reports that have been implemented in full or in part, and 1 report that recommending no change, and 3 reports outright rejected by the administration, and the 2 reports to which the administration has indicated that they have no intention to implement. Well, we will give response to the remaining 17 reports. There are some progress. In the coming 2 to 3 years, we will, by way of legislation, implement the recommendations. In fact, for a number of reports the administration has drafted, including the report in 2005 in relation to access and custody, and one that is in 2006 in relation to criteria for service as jurors, and a report released in 2011 in relation to enduring powers of attorney, personal care. Starting from last year, the LRC will discuss in every meeting the progress of implementation. The LRC liaises with a policy bureau and department, asking them to give information about the most updated information of progress and implementation. I thank everyone who for their cooperation. These reports are uploaded onto the LRC's website. I will continue together with the panel, members of the LRC and other panels, working together to monitor the implementation of the recommendations. So far, we have 2 members who would like to ask questions. 5 minutes each. First, Mr. Dennis Kwok. Thank you. We attach a lot of importance to the work of the LRC, as always, so that government departments and bureaus will take the recommendations and reports seriously. However, we see that it takes a very long time for the recommendations to be implemented. I remember the S4J once said that they would like to change the mode of operation of the LRC, say for example appointing full-time members to take up the work and to elevate the level of the commission so that there will be more full-time staff members working in the commission. We'll find ways to enhance the professionalism of the commission and to improve the efficiency of the commission. Do you require an answer? I've asked him a lot of times this question, and I know that he would like to do that too, maybe because of resource considerations, that the LRC cannot undergo the improvement it's supposed to. Secretary, I am very concerned about this as well. What I can say in reply is that I hope that in the remaining time of my office, I would like to look into what I can do. We have to take into account resources. There are discussions in the LRC and also in the DOJ. I hope that I will be able to come up with a report. So there's a chance that it can be implemented, is that right? I would do my best. Mr. Martin Liu. Thank you. Class action is very complicated and is a daunting task. And at the same time, there is huge public concern. The introduction or otherwise of it will affect Hong Kong's business environment. Say, for example, unequal weight unequal value in the shares, and also consumer rights. The subcommittee has convened 10 meetings to look into the recommendations of the LRC. So far, I'd like to ask the Secretary, what is the progress of the subcommittee and the working group? And what major difficulties have they encountered? Thank you for the question. As you all know, that after the LRC has published the report because of the complexity of the issue and the extensive scope, an interdepartmental subcommittee has been formed to look into it. As far as I know, that the subcommittee has had discussions on different topics, including, say, for example, consumers. What's the definition of consumers? And when allowing class actions, what criteria should the court adopt? What procedures will be adopted to allow class action, to prevent abuse, and to ensure effectiveness? And will we consider opt-in, opt-out? The subgroup is still looking into these issues. I understand that the work started a long time ago, but we're talking about very complicated issues, and it's just not a legal issue. We're looking at other jurisdictions. We find that some jurisdictions have looked into it without implementing it. Say Singapore, they have looked into it, but they have not implemented it. The consideration, one of which is whether it will affect the competitiveness of the jurisdiction with the introduction of class action. And some others are concerned about the impact of class action on the US and also in the business environment. And there are also concerns about striking a balance to get justice when they're fighting against conglomerates. And there is also concern about the impact of Hong Kong's competitiveness. And if in the end we decide to introduce class action, what will be the legal procedure? And if we decide against it, will there be an alternative to ensure consumers or other people to use other avenues to seek relief or redress? Well, I would like to talk about item 41 under B, that is conditional fees in relation to the supplementary legal aid scheme. Well, we've been fighting for this for many years. When it comes to extending the scope of legal aid schemes, I've received letters. I've been receiving letters over the past few years from solicitors that when it comes to allocation of cases, that they don't really agree.
The supplementary scheme includes more flexibility because it is actually needed by the middle class people. I'm talking about the middle class people who are the lower middle class. When solicitors receive jobs, there are still controversies saying that you always go to the same solicitors who provide service under the legal aid scheme. In fact, this is found to be unfair amongst the legal sector. Of course, if one is involved more, he has more experience, but then there are newcomers to the practice who do not have a chance. And it is said that to a certain extent, when a client is approved to have legal aid, maybe there can be a rotation system. Say, for the same kind of expertise, there would be more than one lawyer available. Even if you also approve the engagement of a QC or SC, you should also allow a rotation system. It's more true for solicitors. There are more than one firm, I'm sure. So can you consider this aspect, SJ? Thank you, Chairman, for your question and your comment. Since legal aid is not part of the work of the DOJ, I don't think it's appropriate for me to make any comments on this occasion. What I can do is to relate your view, Chairman, to the relevant parties. I hope, SJ, you can help reflect the view, because these questions have been with the legal sector for many years. And then I have another question, and that is paper 03, number 5. It is said that the LRC is doing 6 studies. I'd like to know whether there is a timetable for these projects. Say, for example, third-party funding for arbitration and periodical payments for future pecuniary loss in personal injury cases, particularly E. I'd like to know whether you have any timetable for doing these studies. I'd like to know the timetable, please. This is paragraph 5 in paper 03. You say at present there are 6 ongoing projects under study by LRC. What do you mean by ongoing? Are you doing research, or do you have a timetable? Some of them are more urgent, some are more controversial. Mr. Liao, for example, mentioned a very controversial point, and perhaps you can research into it, and then you can come back to discuss with us as to what should be done, because we know it's controversial. So what are your target dates for these 6 studies, please? Thank you, Chairman, for your question. Certainly, we'll try to complete every item as soon as possible, but the progress of work will depend on the complexity of every issue. You asked about para 5 and 5E, third-party funding for arbitration. I can let you know that we are at an advanced stage of our work. In other words, we hope to be able to submit the first consultation paper in the short term to consult the public. Our target is that within the next few months we can submit that paper. The members who are doing research, or other members making comparisons with other jurisdictions, they have been working very hard and they have supplied a lot of information. Now, also I can mention 5B, causing or allowing the death of a child. I understand that this has taken some time already, but unfortunately, originally the subcommittee chairman has passed away, and so this has taken longer than expected, but we have already appointed a new chairman. We hope we can catch up with the timetable. Thank you, Chairman. Next, Mr. Tenka Pugh, first round, 5 minutes. Thank you, Chairman. I can refer to the table in the paper. There are many items that are very close to my heart, and some of them have to do with social welfare. First of all, guardianship and custody, and also the enduring powers of attorney. You say there will be consultation in the 3rd quarter of this year, but we are already in the 3rd quarter. It seems you are just saying that you will consult the professional bodies and the judiciary, but it's very clear that this has a lot to do with social welfare organizations and even the public. They need the attorney papers. Some may even involve asset or estate management. I'd like to know what is the scope for consultation. We are already in July. You don't have a lot of time, and when you come back, we need to set up a bills committee to study it. So what is your timetable? And are you talking to social welfare organizations on this one? And secondly, stalking. In the table, you say you have consulted the Constitutional Affairs panel of the LegCo, but it seems there will not be more work done. You are saying that the proposals are being considered or implemented. So are you going to consider doing something about stalking? And also, will you deal with some issues first, say if it is stalking amongst family members or stalking by creditors or debt collectors? Will you do it in different parts, or are you going to deal with stalking as one matter? SJ. Thank you, Mr. Tang, for your questions. First of all, enduring power of attorney and the consultation work. As we have written, we are going to seek the views of the legal professional bodies, the judiciary, and other stakeholders. By stakeholders, we include what Mr. Tang has mentioned, and that may include everybody and every organization in society who may have a view. We definitely understand that with regard to enduring powers of attorney, there are legal technical issues, but there are also other social concerns. Say, for example, under what circumstance the policy should allow this to take place, and whether there will be any impact on caring for the elderly, etc. When we say other stakeholders in the paper, we would include the people you have mentioned, Mr. Tang. Your second question has to do with number 45 of the table, and that is stalking. My understanding is that the Constitutional and Mainland Affairs Bureau regards this as a very controversial subject, and there will not be any follow-up at this stage. But the CMAB would keep watch of the developments in Hong Kong and also developments in other jurisdictions. Mr. Tang. Thank you, SJ. If you are saying that the CMAB will be the steering department to deal with stalking, but let me talk about the enduring powers of attorney. You say the third quarter. I don't know what your timetable is like. You are going to consult the legal profession and also the public in a way. So what is the timetable? Because you don't have a lot of time. We are already in the third quarter. And also, have you heard any opposing views so that you should expect a long political consultation? Thank you, Mr. Tang. We are looking at a consultation period of 3 months. You ask me whether we are aware of different views or different political observations. Well, I can't say there are none, but whether the discrepancies will affect future law enacting work, I think I cannot make any accurate assessment here. Of course, we hope that we will look at it from a legal angle for the welfare of Hong Kong people. We hope this will not be politicized. Okay, if no other members have questions, I'd just like to add a point to what Mr. Tang said about stalking. Some members have said that there doesn't need to be any follow-up, but in fact, this was first raised by the community. We, of course, understand that we should balance the interests of different parties, meaning press freedom, freedom of expression on one side, and in fact, there are complaints amongst the community about debt collecting. Even if the amount involved is very small, people were stalked, and as you know, sometimes people cannot cancel auto-pay contracts. Remember, there was a bloody incident with regard to a pay TV station. And also, when you look at women involved in stalking, say if they don't want a love affair to go on, and the women can be stalked by the ex-lovers, and this can have psychological effect on the people stalked. Some people may be affected by depression if this is done on a prolonged basis. Now, since this is discussed at the CAP and also at the LRC, we'd like to do some follow-up. I hope the SJ knows our view. In fact, people are still discussing this. Last year at the CAP, some members said there needn't be any follow-up, but I am still receiving calls for help. We need to know how we can help the people concerned. Okay, if there are no other members asking questions on the paper, the discussion will end here. I thank the SJ and his colleagues for coming along to answer questions. Thank you very much. Thank you. Next, procedure for the making of subsidiary legislation relating to the legal professional bodies. The relevant papers are CB bracket 4 13 bracket 04 and bracket 05. We'd like to invite the Deputy Law Draftsman, Mr. Gilbert Moe, to take us through the paper with regard to procedure for the making of subsidiary legislation relating to the legal professional bodies, and also the role of the DOJ in such procedures, and also what measures have been taken by the DOJ to help legal professional bodies when they make subsidiary legislation. I hope members will know that on the 8th of July, the Law Society has included its correspondence with the DOJ with regard to the protocol that is to be drawn up. That is for members' reference. So first of all, can I ask Mr. Gilbert Moe to introduce the paper, please? Thank you, Chairman. We have provided a discussion paper that is CB bracket 4 1313 bracket 04 to introduce the procedure for the making of subsidiary legislation relating to the legal professional bodies. Some legal professional bodies are empowered by laws made by the Legislative Council to make subsidiary legislation relating to their profession. To respect professional autonomy, the DOJ doesn't have a formal role in the making of the legislation procedure. The only role is that the law drafting division of the DOJ will support the relevant bodies with their professional input, and this will be done on two levels. One, the draft made by the professional bodies will be vetted by our colleagues to make sure that in terms of formatting and texting, that they are in line with our present requirements.
In the process, we will fully explain our role to the relevant professional bodies, and we do not participate in the drafting of the content of the subsidiary legislation. We will make suggestions on draft on the text and also style, and if there are no further questions, that there will be a blue copy for the professional bodies to deal with the actual making of the subsidiary legislation and Gazetto. 2013, after the incident of Solicitors General Costs Amendment Rules 2013, when we send the draft subsidiary legislation back to the professional bodies, we will remind the non-government body that they are fully responsible for the subsidiary legislation. We have also drafted guidelines to help. We had a lengthy discussion with the Council of the Law Society that the law drafting division plays what role, and then the council will play a different role. They have been fully explained to the council. I believe that the letter has been attached. Let me say again that when it comes to the drafting of subsidiary legislation, the DOJ's role is related only to the format. We have introduced in measures to ensure that we will, as far as possible, remind the professional bodies to pay attention to the process so that the incident will not happen again. And well, it has been included in their checklist as well. Any questions, Mr. Dennis Kwok? 5 minutes each. I don't need 5 minutes. I know that is not really anything to do with the DOJ, and we trouble you to ask you to come today. You're very professional. You won't commit such elementary mistakes. But unfortunately, we have seen this mistake. Fortunately, there is not much damage done. Well, sometimes the Law Society will deal with bills. Would you maybe give them more support or suggest to them that they can recruit retired law draftsmen to help the Law Society to deal with drafting? I know that there are people who provide such service in their personal capacity. They may charge a fee, but at least you know that they have the experience and the competence to do it. When it comes to limited liability partnership that is now being dealt with by the Law Society, it's been going on for very long, and we would like it to be introduced as soon as possible so that it will come into operation. But they need more time, they said. Can you help in any way? Mr. Mo. Thank you, Mr. Kwok, for your correct understanding of our role. You ask us if we can use our contact to help the Law Society to find people with experience to help them with their drafting work. There has been similar arrangements made for the Law Society. I have recommended a number of people who have left us to help the Law Society. My understanding is that the Law Society did approach them. I believe that with their help, it will be easier for you to vet their work. Is that right? If they use people that you recommended. Well, it's our experience that if someone with experience in law drafting has participated in the drafting procedure, then it will be easier for us to make sure that the format and drafting style conform to the established practice. Mr. Tan Ka-pil. There is an established procedure in place. I don't know whether the question should be directed to the DOJ. We are talking about professional bodies, and we should respect professional autonomy. And in point 7, well, sometimes it's in relation to relations with the client. Say, for example, for bar association, it's in relation to professional practice, conduct, discipline of barristers and pupils, and when it comes to law society, indemnity against loss arising from claims in respect of civil liability. Well, when there are views, where should it be raised? I mean, at which stage should it be raised? And what is the relations between the Chief Justice? Because it says that there should be pre-approval. So is it the case that there is just an approval, or it's not approved, or there is interaction that there will be counter proposal? Mr. Mo? Perhaps for the second question, I will defer to my colleague, Ms. Wang. Mr. Tang mentioned about paragraph 7. That is delegation of power to legal professional bodies. To a large extent, it's related to their self-regulation. Say, for example, professional practice, conduct, charging. When you mention about indemnity, we're talking about the professional indemnity scheme. It's a scheme that is managed by the law society. Members will have to pay a fee, and if there is a claim, then the scheme will deal with it. So it's still related to the self-regulation of the profession. The legal practitioners ordinance have already given the power to the professional bodies. The government only provides a only plays a supporting role if members of the public has input, then they can write to the law society. There is also a gatekeeping mechanism. The Chief Justice will give approval. There is interaction. As far as I know, say for example, if the law or the bar association has finished with the first draft and it's been vetted by the law drafting division, then is submitted to the Chief Justice. The Chief Justice may express views, and the CJ may consult the DOJ. The DOJ will give advice. So we will be able to keep the gate for the interest of the public. Comments will be given to the Chief Justice, and if deem fit, it will be reflected or reverted to the professional bodies who will decide whether to change their version. Without prior approval, they cannot gazette the subsidiary legislation. They can't even introduce the draft legislation to LegCo. And of course, the LegCo can use the scrutiny to safeguard the interest of the public. Mr. Leung Kwok-hong. Well, there's the role to be played by the DOJ and the professional bodies. There is delegation power. They will formulate subsidiary legislations to regulate themselves. The CJ can give a prior approval. And as a result, LegCo has the smallest power. If we think that what you've submitted is not in order, is there a mechanism for us not to endorse it? Mr. Mo, the power to make subsidiary legislation is given to them by the law. We have to comply with Section 34 of Cap 1, that is Interpretation and General Clauses Ordinance, to submit the same to the LegCo. And the LegCo has the power to amend or not accept the subsidiary legislation. I also have some questions to ask, and it's related to paragraphs 15 and 16. Well, for some bodies, if they want to change the subsidiary legislation related to them, say for example university, yes, it's easier, and there is power for the LegCo to reject it. And we've actually done something similar. And sometimes they are unable to convince members of the functional constituency and the geographical constituency to accept that. Well, I know what happened. I know what happened with that set of rules. It's my experience that because I have experience in introducing 2 private bills, and the president said they would forward it to the DOJ, and one time the DOJ sent a letter to the president, which is forwarded to me. I wasn't convinced, but they use Rule 74, and it's very difficult for us to overcome that. And it's related to a major livelihood issue. The president once again sent it to the DOJ, and we have to prepare our own translation. We do this kind of work. How can we go out and find others to do it? And we hope that amendments can be made. It goes back into...
I'd like you to explain. You can reject us as if you also refer to Section 74. Sometimes we don't want to agree with you. Sometimes you say there is a minimal impact on public expenditure, so you reject us. Very often you use that ground. And sometimes we say you should give more discretion to the lawyer to help somebody who is in dire need. I won't refer to my case because I'm working on Chapter 572. My question for you is it that the legal drafting division will already make a judgment? Chairman, we are not talking about subsidiary legislation, but private bills now. Actually, the legal drafting division will just be limited to make sure that the format is in line with the form of bills and also in line with the ROP of the LegCo, and then a certificate will be issued by the law draftsman. But with regard to Article 74 of the Basic Law, that would be handled by the Legal Policy Division, and our legal advice will be supplied to the executive. That would reflect the stance of the administration on that bill. So the two are different. Now let me talk about the details. If we submit it to you, you only look at the format and you will give us a certificate, and then you will again pass it to the Legal Policy Division, or would it be done by the LegCo president? It seems two divisions will look at a private bill. Is that right? Can I defer to my colleague? From what I know, if there are private bills submitted by members, and since there is Article 74 of the Basic Law, it should be for the President of the Legislative Council to invite the administration to comment. Our colleagues will look at the private bill from the angle of the Basic Law to see whether it is budget neutral or whether there is an impact on public policy. And the comment will be referred back to the relevant bureau, depending on the scope of policies proposed by this private bill, and then the bureau will put back the view to the president, and the president may refer it to members first before he makes a judgment. Is it my understanding that we will issue it to you to get a certificate, and then you'll pass it back to the LegCo president, and the president will issue it to the Legal Policy Division, and they will comment whether there is any contravention to Article 74, yes or no, and you will give your view to the LegCo president, and only then we will know whether we have a chance to discuss it at LegCo. Yes, we look at both the format and the contents. So every time there is a private bill, two divisions of the DOJ will have a chance to comment. Yes, because that is the requirement of the Basic Law. If there are no follow-up questions, this is the last meeting of the year. I'd like to thank you. Also thank the Deputy Law Draftsman for coming along. I wish you a very happy summer. Thank you. Also thank the Secretariat and also all the staff of the Legislative Council who have worked very hard to facilitate our meetings. Thank you.